journey of arbitration begins with an arbitration agreement. That is what Section 7 says. But important thing is that what is called a written agreement? Because nowadays, in the evolving business environment, maybe you are exchanging the emails, or sometimes you also say on WhatsApp that, okay, I agree to SIAC as an institutional arbitration. What is SIAC? It is in Singapore International Arbitration Center. But that is not important. What is important is that both parties have agreed that we will go to SIAC in case of dispute resolution through the mode of WhatsApp. Now, when there is a dispute, the other party will say, see, there is no written agreement. You have just sent the SMS or WhatsApp and I have said yes. And this is the specific dispute that came up before the Delhi High Court. It was a case of Belvedere Resources versus OCL Iron and Steel. That case, Delhi High Court said that irrespective of the mode of communication, be it digital or physical, but if the parties have agreed to refer the dispute to the arbitration, it will be a valid contract. Another interesting question that stalled thousands of arbitration in India was if there is an arbitration agreement and if it is improperly stamped, would it be a valid agreement? There was a dispute which stalled effectively all the arbitrations in India, and in the case of NN Global, Supreme Court said that if there is improper stamping, then that arbitration agreement is not valid. Now, this had a devastating effect onto the business environment. Generally, arbitration agreements are not simple agreement pertaining to arbitration. There are a lot of other clauses, and parties sign it onto blank A4 size paper. Both parties agree, they sign it, stamp it, and ultimately they decide that if at all there is any dispute, they will refer it to the arbitration. Now, Supreme Court says, no, this is not a valid arbitration agreement. In that scenario, the 7 judges bench of the Supreme Court of India took up this issue in reference, and that reference was interplay between Arbitration Act and Stamp Act of India. Supreme Court said that improper stamping or non-stamping was a curable defect, and therefore that defect cannot stall the arbitration. And with this clarity, all the arbitration which were stalled in India came to be resumed, and today there is a more confidence in the business community. Whether agreement is signed by way of digital communication or agreement is properly or improperly stamped, but yes, there is an assurance that yes, arbitrator will be appointed, arbitrator will have all the powers to decide its jurisdiction, he will pass the award, and there is a lot of surety about the enforcement of the said award. And therefore, arbitration environment in India is improving. We keep discussing about various aspects of arbitration law in upcoming journey.